I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Melissa Bailey is a shareholder at Ogletree, Deakins, Nash, Smoke, and Stewart, and focuses her practice on occupational safety and health issues, and also serves on the firm's board of directors. Lori Severson is Vice President, Loss Control Consultant in Lockton's Denver office. She has 23 years of safety experience working in numerous industries and has held a variety of environmental health and safety-related positions. And now I'd like to turn the program over to our speakers. Lori, the floor is yours.
Thank you so much. I'd like to thank LexisNexis for this opportunity to speak on such a very, very important topic that's facing our nation. As a safety professional facing prevention programs in multiple industries, we're seeing that actually about 4,547 employees die from fatal injuries in the workplace per year. So safety professionals and our work is very important, and your partnership is critical for risk management success. We see that about 506 of those employees are due to a workplace violence event. That's why Melissa and I are going to cover the first 5 points of this really important topic to define what workplace violence is in the United States, paint the portrait of the history to these events, and go over the OSHA criteria and citation history that OSHA is putting on industry to address this critical statistic. You know, the Secretary of Labor has a legal burden of proof under the review and commission and circuit court law, and Melissa's going to cover that extensively. I will share with you from a safety perspective how one can identify risk factors and put in effective and sustainable prevention programs so that you can abate OSHA citations related to workplace violence, as well as just completely understand which industries are at high risk for this type of event. We will close with a summary and welcome your questions. The workplace violence, what is it? Every story begins with a great definition, and I think NIOSH, the National Institute for Occupational Safety and Health, has a very simple definition that is very useful, but it's limited. Physical assault, threatening behavior, verbal abuse occurring in the work setting. As one who works with the healthcare industry extensively, I welcomed the World Health Organization and the International Councils of Nurses who expanded that definition to include that coming and going from work, because that certainly is a trend that we're seeing in the workplace. More employees are put in their home. They're going into other people's home to do some side of service or care. So expanding that definition to be explicit about the coming and going and their safety and their well-being is a definition that I think is important for all workplace violence programs to recognize. Conflict. It is important to make the distinction between conflict in the workplace versus violence. Conflict is oftentimes a precursor to a violent event, but a lot of times that's just resolving itself very positively and with minimal intervention by others, reasonable means. But when we see worker-on-worker violence in the work setting, and abusive language being persistent and allowed and getting to be systemic within an organization, that it's not uncommon for us to see that these types of organizations have the escalation from conflict to full-blown violence. And so resolving conflict as early as possible, and I'll talk about what types of conflict there are shortly, but being able to mitigate that sooner versus later will be very important for employers in the workplace. Crisis development really goes through 4 stages. When we have stage 1, it's that simple stuff that we see in the workplace, the normal stress, the normal anxieties of getting our work done and interacting with our coworkers. And they might appear a little bit lost, but they're probably going to get over it. When we get to a stage 2 event in a crisis, we're seeing that there is definitely a higher type of event going on. So one might have a quavering voice. One might have nervous habits of pacing a little bit or tapping their foot. Stage 3 and Stage 4 are the ones that we see and hear on social media. They are those events of severe stress, severe anxiety, where one is confronted with a terrible medical diagnosis and they feel that it's so painful they can't cope with that. They have little reasoning capacity and their ability to communicate is very, very shallow. They might actually start to do the threats. They may have physical indications that they're giving to people. And Stage 4 is full-blown crisis, when one is at that ultimate pain point where they need to end that pain. They need to make that full-blown event of violence against someone or something in the workplace, and that behavior cannot be changed at that point in time. Know that these 4 stages of a crisis development can take seconds to minutes. I'll talk about some of the common events that happened in our history, and you'll know some of them just took 10 minutes or less. The greater amount of time will be spent on crisis resolution in any organization. So what are the attributes that an employer should be looking for that may produce a violent event? I've listed a long list on the next 2 slides of possible risk attributes that human resource professionals, managers, supervisors should be looking out for in their workforce and in the hiring process. But know this, there really is no one profile. I can't give you 3 bullets. They're going to tell you that person, because they do these 3 things, is going to produce that violent event. You really have to look at this list and then put it in combination with things like a firing that didn't go very well, a promotion that was missed, someone with mild mental health issues that is put in a position of being criticized. When we look at this list, we can say, hey, I've seen that in the workplace. It doesn't ultimately mean that there will be violence, but it can contribute to it in combination with stressors in the workplace, which leads to the safety and security professionals' definitions of workplace violence. Type 1 violent acts are those criminals who are coming into a workplace to commit a robbery typically, and these are taking place in retail settings. It could be the taxi driver, and oftentimes this is where the FBI has identified that 80% of homicides take place, unfortunately. Type 2 violence is customers, clients, patients, students, inmates in the prison system, when they are acting out against their staff that they are interacting with. And this can be such things as in the insurance industry, in the claim side. If we're denying a claim, a customer may become very upset with us denying that claim and actually come to our facility and try and act out against an adjuster who's saying, no, we aren't going to compensate you on a claim. So in our industry, type 2 can be possible, as well as you will see that in the healthcare industry and the government industry. Type 3 and Type 4 violent acts are the ones that we typically see in the media. These are the extreme events, and these are the ones where a disgruntled employee, Type 3, is coming back to do some harm to a human resource professional or a manager who said something or didn't say something to an employee that made them disgruntled, and they act out. And Type 4 violence is when a personal relationship wanders into the workplace and wants to conduct some type of violent act against a person that they are in a relationship with. So who's at risk for workplace violence? As I mentioned, before 9/11, I've been in the safety industry for 20 plus years, we always talked about the retail, the 24-hour operations, the taxi drivers, those that have properties with multiple entry points. The lone workforce has always been part of that, and I can't emphasize enough that that workforce is just growing like crazy. And those that have contact with the public and are exchanging cash or have medicine, pharmaceuticals on them, or any type of drug exchange. Those high crime neighborhoods in certain communities are going to contribute to a workplace violence event. Your environment is hugely impactful on this event happening. And home care nurses. How many of you have the sandwich generation going on where you're taking care of an older parent and you need some provider to come into the home? They're coming and going in all types of settings, and they are at great risk for workplace violence. So it's expanded since 9/11, sadly, to beyond government employees and retail and taxi drivers, to where I'm saying almost any employment setting has potential for workplace violence. Sadly, there's only about 10 pieces of state legislation on the books that address these violent acts in the workplace. So if you have assault and battery, cyber social media bullying going on in your workplace, and you're in one of these 10 states, this list reminds us that we do have some government oversight for workplace violence in a few states. Melissa will go into the federal legislation that's out there, but there is no specific federal legislation that governs workplace violence. So let's take a look back in our history, in the beginning of my safety career, beginning in the mid-'80s, where one of the national events that really tipped workplace violence into the public consciousness began in '86 in Edmond, Oklahoma. This is where that myth of going postal, that term was coined, and it's a myth because the postal industry really does not have more shootings going on than other industry sectors. The lone workforce are those that work alone, and this individual didn't work alone. This individual came to his office. He was a part-time letter carrier, and he was disgruntled because he faced dismissal. His work history was sketchy, and he proceeded to enter the workforce that day, shoot 20 of his colleagues, and killed 14, one being himself. This, by definition, is a Type 3 violent act, and it's one of the first ones that just raised that, oh my gosh, what is happening, what is workplace violence, and coined certain terms related to this subject. Equally in Newington, Connecticut, 98, about 12 years later, a 35-year-old male accountant entered the workforce right on time. But he was really angry about a salary dispute and his failure to get a promotion. He had knives and guns, and he proceeded to chase his management across the parking lot. It was actually the CEO, and killed him and himself. It was a Type 3 violent act. Melrose Park, Illinois, in 2001, just a few short years later, experienced a very long-term employee. He had been there 39 years. He was a fork truck driver, a technician. He was fired, though, because he was found to be stealing parts from the plant. And so he was convicted in federal court in 2001 for this theft and was to be entering a 5-month prison term, February 6th. But he decided the day before that that was not going to happen, and he was going to retaliate, where he shot 7, killed 3, again, a Type 3 violent act. Meridian, Mississippi in the South experienced in July 8th of 2003, a 46-year-old male assembler was attending a mandatory ethics and diversity meeting. He was known to have said statements in the workplace about other races, that he didn't like those people, and so thus HR mandated that everybody have diversity training. He said, "Y'all are messing with me," left the training, went out to his truck, brought in arms, put a bandana on his head, and proceeded to kill the staff, some staff in the meeting, and went into the engineering office and killed the leadership that had directed him to be at this meeting. Our education employers are certainly in the media, and one that watches the news has seen that it's expanded not only from our universities, our high schools, but into our elementary education settings. As a resident of Colorado, of course, our historical event from '99 at Columbine High School, where the boys injured 21 of their classmates and killed 12 amongst themselves, was historical and life-changing for everybody in the state of Colorado, and has heightened the security that we have in our schools to one of the best in the state, sadly. Red Lake Reservation High School in Minnesota also experienced a shooting. Recently, 2010 in Marinette, Wisconsin, 23 hostages, few killings, but taking hostages. You can imagine the traumatic event for these students, these teachers in these education settings. And most recently in the news, Sandy Hook Elementary, very devastating elementary shooting, first time ever in the country. To see that in that setting, very painful. But there are ways to prevent these, and I'm going to outline those shortly. But on October 24th in 2014, we recently watched in the news the Washington High School where the young man texted his friends to the lunch table and proceeded to shoot family members and friends. Very tragic events in education, healthcare employers, equal laundry list, just tips of the iceberg here that I'm sharing with you to emphasize this portrait of workplace violence encompasses all work settings. And one who hears that, oh, mom is so severely ill she's not going to survive, and he proceeds to take out a gun and shoot the physician in 2010 at Johns Hopkins, very tragic, to the point where I think we're starting to see physicians arm themselves. July 28th, 2014, at Mercy Fitzgerald Wellness Center, the physician shot the psychiatric patient after he had just killed his caseworker. The Department of Justice surveyed 55,000 plus workplace violent crimes and found that those in psychiatric, social worker, and mental health profession are 4 times as likely to be assaulted on the job. And we see that this lack of funding for mental health service providers and the loss of inpatient psychiatric beds is greatly contributing to this risk for these healthcare employees. So moving from the identification of the healthcare industry as an additional player that's at risk for workplace violence events, I can't emphasize enough the government employee risk factor. April of 2013, the Bureau of Justice Statistics indicated from a study from 2002 to 2011 that their annual average rate of simple assault in the workplace against government employees was 18.9 per 1,000 versus the 4.6 per 1,000 of private sector employees. So the events happening in the fire, police, EMS, government employees is at great risk for workplace violence due to the stressors that involved in that type of work. 96% of workplace violence was against employees at the state, county, and local employee level, where there is 81% of government workforce. So those firefighters have had an increase in their rate over the last year. There were some significant events across the country fighting national fires that has contributed to that. Again, from a safety perspective, we feel many of those incidents are preventable and unfortunate, and sorry to see these statistics on the rise. In 2009, we have seen our military bases being attacked by others, and also in Ottawa, Canada, most recently, October 22nd, in the news, the Parliament building being attacked by extremists. So workplace violence in the government setting, great risk and important for those entities to be practicing their workplace violence programs. Courthouses. In 2012, in the publication Disorder in the Court, Incidents of the Courthouse, they have found that there were 209 incidents in the years 2005 to 2011. These courtroom violent incidents are on the rise, and it is attributed to the cases. And so working to identify the cases and the attributes that are putting stressors on people, because that person has to commit a violent act in a courthouse and identify a target, determine the incident, and attempt to circumvent extreme security at times. So these people can be very, very aggressive in their efforts, and the courthouse is one that has to consider those stressors. At this point, I pass the presentation to Melissa to identify the OSHA components of this topic.
Thank you, Lori. Some pretty sobering statistics there. Before I go on, I've got two questions I want to ask you. I've been kind of keeping an eye on the questions that have been coming in, and someone asked, you used the term lone workforce. What do you mean by that exactly?
Yeah, very good question. For me, in the safety perspective, the lone workforce are those home health aides that go into the home to help senior citizens lead independent lives. They could be RNs. They could just be a nice man or woman in the neighborhood that stops by to help them do basic chores. So those can be lone workers. I will tell you, though, that many employers have employees that travel for their job, and at times they will be alone in traversing airplanes, going to a project or doing presentations, conferences, etc. So a lone workforce can be just an individual traveling alone for work to conduct it in another state, for example.
Thank you. The second question I had, you gave us some statistics there at the beginning. I'm just wondering, over the course of time, have the numbers of these incidents increased or decreased or stayed about the same? And I guess one reason I ask that is certainly we have more media than obviously we did, 20 years ago. So when you look at those trends, what are you seeing in terms of increasing or decreasing?
In the world of OSHA, they do keep statistics with the Bureau of Labor and Statistics on the annual fatality rates. So one can always resource the Bureau of Labor Statistics on annual fatal injuries. We are on a slight decline, but if you look at the number of workplace violence events per year, they are on the increase. And certainly I mentioned the fire industry has had an increase of some workplace violence events, those in the military and those in the education setting. So it's particularly important to emphasize that, for example, the education industry is increasing, and they are ones that typically do not have safety professionals on staff. They have multiple campuses, very open, and they don't have workplace violence on the tip of their tongue in their curricula as they become teachers. So the partnership with safety professionals in the community, whether it's police and fire, to these organizations is very critical and important.
Thank you, Lori. That's very helpful. Well, let's turn now to what OSHA's involvement is in all of this. So let me start by framing the issue with really some information that Lori's already given you. As she mentioned, the Bureau of Labor Statistics keeps information about workplace fatalities. So you can see the numbers, and you see that, of the 4,557, 506 of those were homicides. Homicide is actually the leading cause of death for women in the workplace. Regardless of how it manifests itself, clearly it is a big issue for society as a whole, and I think we have a difficult time measuring the economic cost of those sorts of fatalities, but it's clearly substantial. And I think with workplace violence, as opposed to other types of workplace fatalities, you certainly have indirect costs that can also be substantial in terms of the domino effect and what it's going to mean for the other employees in that facility. So as someone who practices law in this area and unfortunately sees workplace fatalities of all different types, there's no question that any workplace fatality is horrific and tragic for that workforce, the community, the company, everyone involved. From my perspective, I think when you're dealing with a fatality that results from workplace violence, it is immeasurably worse. And I think the reason for that is that once that happens, no one feels safe. You think about a workplace fatality that results from someone who falls because they're not wearing their fall protection equipment. Well, that's certainly horrible, that's certainly tragic, but I think other employees can say, oh, well, I need to make sure and wear my fall protection, or I need to make sure and drive my forklift more slowly. When, it's someone that comes into that workplace with a gun and kills somebody, I think your workforce invariably just doesn't feel safe, and it's hard to put quantifiable measures in place to say this will never happen again. It's just a different animal, I suppose, is how the quicker way to say it. So when we think about the OSHA piece of this, there is no specific OSHA standard that deals with workplace violence. Workplace violence is dealt with from OSHA's perspective with what we call the General Duty Clause. which was really kind of a catch-all provision that's actually in the Occupational Safety and Health Act. And that particular clause requires employers to maintain a workplace that is free from recognized hazards. The other OSHA provision that comes into play is the record-keeping rule. And the reason that comes into play is because when you have a workplace fatality of any type, you have to call OSHA and report that fatality. You also have to call and report when you've had an incident that results in 3 or more employees being hospitalized. So if you have that workplace violence event, if those criteria are met, then you're going to call OSHA. That's going to cause them to come and perform that inspection and potentially issue that general duty clause citation. We're going to talk a little bit later about how even if you have an incident that doesn't meet those criteria, OSHA is pretty likely to show up anyway. But those are really the 2 OSHA provisions that come into play. So just to kind of frame the issue a bit, OSHA has a couple different types of inspections they perform, really 4 different types. Complaint inspections, and that's when you're going to have an employee or former employee, a labor union, someone of that nature who calls OSHA and complains or actually fills out a formal complaint. So that clearly can result from either a workplace violence incident or, even more likely, just a threat of workplace violence. Their referral inspections, those can come from other agencies. Honestly, more likely they come from the media. So that may be a situation where you have, for example, a retail facility that's robbed. No one's injured, but that retail facility is robbed. You know, hearing that report on the news can cause OSHA to say, we're going to go inspect that facility and see how they're dealing with workplace violence. Fatality catastrophes, we've talked about that a little bit. That's going to be when you are required to pick up the phone and call OSHA and tell them you've had this incident and someone's either been killed or you've had 3 or more employees hospitalized. And then programmed inspections, those are inspections OSHA performs of specific industries. So OSHA currently doesn't have a programmed inspection system specific to workplace violence. But I will tell you that when they go and inspect healthcare facilities in particular, that is an issue they will look at. So in certain industries, healthcare, late-night retail, those sorts of industries, OSHA is clearly going to be looking to see whether or not those particular employers have workplace violence programs. Hazard alert letters are what OSHA sends when they decide they are not going to come out and do a physical inspection. So if you have an employee or a former employee or a labor union who files an informal complaint with OSHA, rather than coming out to inspect, OSHA may just send that employer a letter and say, we've gotten this complaint, you know, tell us how you deal with this issue. The reason I mention that is because it's becoming more and more common, at least among my clients, that OSHA sends those letters because an employee has complained about workplace bullying. So typically the response to that letter is, you know, this isn't really a safety hazard, we're dealing with it through HR, but I'm finding myself drafting more and more of those types of letters, which is the reason I mention it. So as I said a little bit earlier, the record-keeping regulation is going to require the employer to pick up the phone and call OSHA if those particular criteria are met. What we've been seeing over, say, the past, 5 years or so, is that even when you don't have to report something to OSHA, they're coming anyway. And the reason for that is that they're monitoring the news carefully. They have agreements with local emergency rooms and hospitals where those ER doctors will call OSHA if someone's admitted to the hospital because of a workplace injury. They have reached similar sorts of agreements with EMTs that may show up at the workplace to transport someone by ambulance. So more and more, the fact that you do or do not have to report something, it really isn't making a difference. If something happens, OSHA is more and more likely to show up and do that inspection. So how does OSHA prove a general duty clause violation? They need to prove 3 elements. OSHA is going to have to prove that there actually is a hazard of workplace violence. They're going to have to show that the employer or the industry recognizes that hazard. And then finally, they're going to have to show there's a feasible abatement method to either eliminate or mitigate that hazard. And it's often that 3rd element that is the most difficult to deal with. So let's talk about them individually. In terms of employer recognition of workplace violence, that can come in a variety of forms. If a facility has had past occurrences of workplace violence or even had near misses, and I guess what I mean by that is suppose they've had an armed robber come into a facility and the robbery hasn't occurred for whatever reason, the person runs away or something, well, that's a near miss, but I mean that should be tipping off that facility that they've got a problem they need to deal with. Injury and illness records, OSHA 300 logs, OSHA 301 forms, those are the records that facilities are required to keep that describe work-related injuries that have occurred at their facilities. Going to the healthcare setting, if you have reports on your 300 logs about healthcare personnel being assaulted by patients or something of that nature, well, clearly that's going to show that that employer should recognize that they have a workplace violence issue potentially in their workplace. Complaints and grievances about workplace violence, those may come through safety committee meeting minutes. They may come through complaints from employees. I think in terms of those sorts of things, it's not, those kinds of complaints or grievances may not prompt that employer to actually take action. They may read that complaint and say, we don't believe that's a hazard because we already have a camera system or because we already have panic buttons. Whatever the case might be, I would just urge that it's important to deal with those complaints in some way rather than just letting them hang out there. Because if you do ultimately have OSHA come in, you need to be able to show them that you got the complaint, you considered it, and you dealt with it in some way, even if that way is not taking any action because you didn't feel it was necessary. But it's something you need to consider. Workers' compensation records, and really the same thing as injury and illness records, same with medical records. If you do have a police presence or a security presence at your facilities and they are reporting through their systems that you have some workplace violence potential, again, that's something that's going to cause OSHA to be able to say this particular employer should have or actually did recognize that they have workplace violence issues at their facility. The other way OSHA can show recognition is through industry recognition of workplace violence. And that could be, that's a very broad category. That could be a number of things. That can really be any document or study or something of that nature saying, for example, the levels of workplace violence in retail facilities that are open past 9 p.m. are greater than they are in other retail facilities. It can be something just that simple. It can certainly be something published by OSHA, and we're going to talk about the different OSHA compliance guidance documents that are out there. It could be consensus standards. I mean, suppose you have a trade association or some other sort of organization that sets standards that talks about recommendations for particular types of industries to deal with workplace violence. State and local laws. Lori mentioned that we have 10 states that do have state and local laws on workplace violence. I mean, certainly I think that those laws could be used to show that, a hazard is recognized in a particular industry. And then finally, I put common sense on there, and I did that somewhat facetiously. But, when these cases actually go to trial, either in the workplace violence setting or really in any setting, I mean, that really is a factor. I mean, you think about a facility, for example, I mean, consider a check cashing facility that's open 24 hours a day that's maybe in a major metropolitan area. I maybe can't point you to a document saying there's a workplace violence risk there, but I think, most of the judges I deal with are going to say, well, clearly there is. You've got a facility that's open at night. You've got a facility that handles a lot of cash. I mean, clearly I think you're going to have a tough time trying to argue that workplace violence as a hazard is not recognized in that particular industry. So the final step in the burden of proof for OSHA is that they have to show there's a feasible means to abate the hazard. And that, as I mentioned at the outset, is often the tricky part. I mean, you can certainly look to see what other employers in the industry are doing in terms of abatement. You can look at what OSHA recommends. You can consult with safety professionals. But the common question, at least when it comes to the litigation piece of this, is, how much is enough? Just to cite a couple examples. I mean, maybe you have a grocery store that has put some provisions in place or some protections in place, such as locking doors. They've got security cameras. They've got a panic button. They've trained employees. If something happens, with the benefit of 20/20 hindsight, OSHA is always inclined to say, well, you should have done more. You should have had a security guard. You should have had, whatever the case might be. So often the argument sort of comes down to that in terms of how much is enough. Another example from healthcare, maybe you have, and this is actually based on a case I handled, you may have an inpatient facility for troubled youth. The particular facility I dealt with had very detailed procedures for how to restrain violent patients. They had a staffing system so that they made sure that they had enough staff members on site at any given time to implement this procedure. OSHA said it's not enough. You should have had different types of PPE in case someone gets bitten by the violent patient. You didn't have enough training. So again, OSHA wants to look at all this with 20/20 hindsight. I think it's important to remember that for OSHA to prove its case, I mean, they can't say in the cold light of day, given this incident, it would have been better if the employer had done it this way. That's not the test. The test is, with the information the employer had and the types of hazards that were being faced, did the employer take reasonable steps to put feasible protections in place? And I think, the other piece to remember is that sometimes OSHA will recommend things that are different than what the employer put in place, but sometimes it's not even clear that those additional steps would provide that much benefit. I mean, in a vacuum, if you look at security cameras, panic buttons, drop safes, and then you add the security guard, well, how much does the security guard really add? I mean, it's difficult to quantify, so I think that's the other piece of it to remember. So these are, as is probably apparent, these can be complicated cases to handle. There are a lot of legal issues that go with these. In terms of OSHA compliance guidance, OSHA really has 3 different sets of guidance that deal with workplace violence. The first is the recommendations for late-night retail establishments, and these came out back in 2009. They apply to facilities, retail facilities that are open past 9 p.m. So I've listed on this slide some of the examples of the abatement measures, such as increasing visibility, requiring drop safes, using physical barriers. You can see that these are incredibly general, these abatement measures. And they really depend, whether or not they would work at an individual facility, really depend on a whole host of issues. So, I mean, I think that the fact that OSHA is unable to give employers a concrete list of things that if you do these, we will say you've done what you need to do, really just highlights the problem. That it's very specific to what is that environment. It's specific to a whole host of things because you're dealing with a hazard that you can't control. You're dealing with a hazard that's coming in from outside of your facility that's going to do some damage because you're dealing with a criminal. So it's very different than the hazard safety professionals are used to dealing with, which is looking inside their facility and figuring out, what is the best way to control this hazard. So it's a different animal. The second set of guidance is for healthcare and social service workers. And so this applies to hospitals, nursing and personal care facilities, residential facilities, and again, OSHA's put in the document recommendations on engineering controls, recommendations about administrative controls. These are honestly even more general, I think, than the examples that are, than the recommendations that are in the late night guidelines. And I think, again, the reason for that is this is a very difficult problem to get your arms around. I mean, Lori mentioned, for example, the lone workforce. You've got the social worker who's going to go into someone's home and try to help them. How are you going to protect that person? I mean, certainly you can think about a system where you always have 2 social workers going. You always have 2 cable installers going to install the cable. I mean, the possibilities are endless. But the question then comes, are those really feasible steps to take given that you're running a business. So these are difficult issues. In the guidelines for healthcare and social service work, they also include information about personal protective equipment, or PPE, and that would be garments that you might put on to avoid a bite from a patient, avoid bodily fluids from a patient, things of that nature. So those do include things like that, which are a little bit more quantifiable, but again, there's no list in there that will tell you if you do this, then we're going to say that you're in compliance. The final set of guidelines are really more enforcement procedures, and these deal with when OSHA is going to investigate, and they apply to all employers. And these are the most recent to come out. So these guidance, these enforcement procedures, they don't have any abatement measures in them. These are just the guidelines that are going to cause a compliance officer or an OSHA area office to say, yes, we're going to investigate, or no, we're not going to investigate. So if we think back to Lori's slide from the beginning about the different types of workplace violence, OSHA is going to inspect when it's type 1 or type 2. If you have customers or criminals that are targeting the people in your facility or your type of business. So if they're targeting your facility because it's a robbery situation, then that's something OSHA is going to want to investigate. If they're targeting your people because it's healthcare, because it's, Lori mentioned kind of the denial of the insurance claim type issue, that's going to cause them to inspect. It's the type 3 and type 4 where OSHA is going to say, that's something we're not interested in. So when you have the disgruntled employee or you have the personal relationship issue, OSHA says in this document, we will generally not inspect in those types of situations. None of this is legally binding on OSHA. I mean, once they have probable cause to believe a hazard exists, they can certainly come in and inspect. So if they have information that one employee is threatening another employee with gun violence or any kind of violence, I mean, OSHA has what it needs to come in and inspect. I will say that generally, based on the number of letters I've responded to that deal with workplace bullying, where maybe there have been some threats of violence, OSHA truly really isn't very interested in that. I've never had them come in and inspect in that situation. I did want to mention, though, that when it comes to type 4, I believe it is, which is kind of the personal relationship type scenario, I get a lot of calls from clients about that, and typically that's a domestic violence type situation. And when you really think about it, you know, you think about the scenario with the female who has left the relationship and you have an angry male, or you can reverse that as well. You know, that man or that woman that's left there and is angry, when they think about how am I going to get to that person, you know, the one place they know they're going to be is the workplace. So it's becoming increasingly common that at least I get calls from clients saying, you know, we need help in figuring out what to do about helping our employee get a restraining order, or, you know, getting some security for some defined period of time to sort of get over this hump. So it's kind of where HR, I think, and safety kind of intersect, but I mention it only because, again, it's becoming more and more common. So looking at some statistics, OSHA's issued 31 citations related to workplace violence from 2007 to 2014. That's not very many. That's really not very many at all. Of course, that number does not include how many times they've investigated workplace violence. I can tell you anecdotally, it's becoming more and more common, not that they're coming in necessarily to investigate a specific incident, but they are investigating whether or not that employer has a program to begin with. And that is certainly true in the retail setting. It's definitely true in the healthcare setting. So it's more and more common that you may not get cited, but during that OSHA inspection, OSHA is going to want to know, how do you deal with workplace violence? How do you control that hazard? So a couple examples of where OSHA has issued citations, you know, high-risk mental health industry where there was a long history of workplace violence and the employer really didn't have anything in place at all. Another scenario, which again is sort of a mental health scenario, where you had an employer in New York who dealt with troubled youth. The issue there was that that employer, I believe, had some pieces in place but hadn't accounted for, number one, how are we going to make sure that we do not have weapons that can be used by the people we're counseling, and have we thought about what we're going to do for the employee that may be attacked? What steps is that person going to be able to take? So it was really more not dealing with those sorts of issues. So if we look back at the general guidance OSHA has issued, that's going to it's what they're going to use to decide whether or not they're going to inspect. There's some pretty helpful actual examples in there of when they will and they won't. So we think about the patient in the psychiatric hospital who attacks a nurse. Is it a recognized hazard? Is there a known risk factor? The answer is clearly yes. Industry or employer recognition, that's a yes as well. Even if there had not been previous incidents, I think OSHA would be able to prove hazard recognition just based on, the literature that's out there. Is there a way to abate it? Now, again, that's always the tricky one, and OSHA, of course, is not going to answer that question before they go and inspect, but clearly there are ways in that industry to mitigate or reduce the possibility of workplace violence. So if OSHA gets a report that that's happened in the psychiatric ward at a local hospital, they are going to come out and do that inspection. Second example, you've got a disgruntled acquaintance stabbing an employee in a bookstore. So known risk factor, no. I mean, the employer could not have been expected to anticipate that. It's not a robbery, not a high crime area. Industry recognition, no. I mean, there's no history here, and again, how could that employer have anticipated this would happen? And abatement, no. I mean, there's really no way to prevent that kind of random act of violence in that particular industry. So in that scenario, OSHA is not going to inspect. They're going to get that report. If that's a fatality, that employer is going to have to call OSHA and tell them. OSHA is not going to come out and do that inspection. Then we have kind of the gray area. Shooting at a local grocery store, is there a known risk factor? They don't know. I mean, OSHA's going to look at, is that a high crime area? What kind of past history do they have? What time did this happen? Industry or employer recognition, I mean, that's going to depend a lot on the parameters of that particular store. Where it is, how late it's open, what kind of history they have, and then abatement, OSHA won't know at that point, is there something they could be doing differently or what measures they have in place. So that's a scenario where OSHA in the guidance says we're not sure if we would inspect in that scenario, but we don't know if there's going to be a violation or not. Then finally, you've got the financial institution. Known risk factor, exchange of money, that's definitely a known risk factor. It's not clear how much of a risk factor it is, but on its face, that would be a risk factor. Is there industry or employer recognition? Clearly, there is. I mean, I think even if that individual employer has not given thought to workplace violence, there's plenty of literature talking about if you've got money in your facility and you deal with you're open to the public, well, clearly, there's going to be some recognition of a hazard. Again, abatement, unknown. I mean, clearly there are things that particular facility can put in place to mitigate the risk of workplace violence. It's not clear at this point whether or not they have put the right pieces in place. So a question I get asked a lot is, do the compliance directives themselves establish employer recognition of a hazard? Or do they establish that abatement is feasible? Certainly in terms of employer recognition, OSHA will argue yes, and they probably will win that argument. I mean, OSHA could say, because we've put out these late-night retail guidelines that give you statistics, that tell you there's a risk of workplace violence if you have these kinds of facilities, your industry has recognized this as a hazard. And again, they're probably going to win that argument. If you are in one of those industries, healthcare, late-night retail, and you have not implemented some of OSHA's recommendations, that's fine. You don't have to. but I think you better have a good reason why you haven't, why you've done something different. So maybe you have a late-night retail facility that's in an extremely low-crime area. Maybe rather than putting, I don't know, drop safes in place, you've decided to do something else. Or maybe you've decided we're always going to have 2 people working instead of doing this other thing OSHA recommends. That's fine, but you need to think all that through in advance. OSHA also often argues that because they have put abatement measures into a compliance document, that means that they're, quote, feasible. They may not win that argument. I've certainly argued they shouldn't win that argument, and I've seen them lose that argument. I mean, just because OSHA puts in a compliance guide that these particular types of abatement measures should be put in place and are feasible, that doesn't get them over the hump. I mean, I think that employers have enormous freedom to choose the sorts of abatement measures, the sorts of protective measures that fit their particular facility or their particular industry. And as long as those measures are reasonable and are intended to and do mitigate the effects of workplace violence, then to me, they've met the requirements of the law.
So certainly are excellent points, Melissa.
Thank you, Lori.
I would add to those and ask a question if you're okay with it.
Sure.
The additional step that we love to say in safety and OSHA loves to see is the word eliminate. You spoke correctly about engineering controls, putting in those drop boxes. You talked about the administrative controls of duplicative staff to be safer. Sometimes you can and can't do those, and one of the things they want us to consider is can we eliminate the interaction, and can we eliminate the hazard completely? So in your assessments, strongly recommend that the word eliminate be added and that teams talk about that. Are there business decisions we can make that eliminate the interactions or exposures completely?
Well, and you raise an interesting point, Lori, because I think especially in the retail environment, you know, you can talk a lot about eliminating the contact with that customer, and clearly, to some degree, that's going to eliminate the problem. But, I mean, I do want people to recognize that, you know, there's still a business component to this. I mean, if you have, and I think most late-night retail establishments do, reasons you want your employees interacting with customers, and that's a perfectly valid reason not to, you know, put that barrier in place. So you're right. Sometimes you can eliminate that hazard altogether. Sometimes you can mitigate it. But I think you do have a lot of freedom to choose the right fit for your particular facility.
Great. A question came in about hazard alert letters. Should they conduct a formal investigation into the complaint? Is a formal investigation something OSHA will expect if it ends up being investigated?
Well, when you get that hazard alert letter, it's pretty much a form letter, and it's going to say, we're going to ask that you investigate this issue and report back to us what you found. So it really kind of depends on the issue. I think when you get those letters and it deals with the workplace bullying issue, I mean, OSHA is not going to expect that you're going to do some kind of formal investigation of what did employee A say to employee B. I think it's enough to say, you know, we know about this situation. This is not a workplace violence situation. I would even reference the OSHA guidance on that issue to kind of make that point. And I would say, you know, we're dealing with this through our human resources system as we do with all employee conflicts. So the short answer is OSHA will tell you in the letter, we want you to, quote, investigate. I mean, I wouldn't say that needs to be some kind of formal investigation, but you're clearly going to need to look into it. But it's very specific to whatever the letter alleges.
Perfect. Great strategies. Well, let's talk about some of these reasonable expectations that OSHA thinks that they're putting on employers by identifying these abatement plans and prevention steps. You know, people often, I really agree with this quote from this unknown fire chief, you know, they think that people are going to rise to the occasion when a crisis comes into play and that we'll all do the right thing, and certainly we do at times. But we find in occupational safety is that more times people are really just rising to the level of the preparation that we provide for them. So we emphasize this point because it's critical to pull this team that I've talked about in my workplace violence writings that I do, that you have to have an outside-in approach. This is a community event. When a workplace violence event takes place, it's not just that individual in one room that got hurt or harmed. It's that extended family of that member. And so therefore we need to include that internal team, which I'm listing in the first two bullets, of course, your management, your legal, your safety security directors, your human resource, trainers, vendor relationships such as myself in insurance, and talk about workplace violence from a compliance perspective, but beyond compliance, because it's always just the minimum. You want to go to the best practice level that's specific to your hazards and review and plan together. So partnering with a 360-degree review of your physical properties of who is next door to us, and what risk do those industries present to us, if anything, and then be partnering with your community safety resources in the police, fire, EMS, so that they can respond in practice drills with you, and always extending those social service networks to those that are in the abuse relationships, etc. You know, one of the questions came in, how many of those homicides relate to the domestic situation? And what we find statistically is that they are on the lower end of the homicides in the workplace, that it is mostly disgruntled employees coming back, disgruntled students, and it isn't always a relationship. So what else are we looking for in the inner team? I talked about going outside the building and doing a 360 review. When we look at that inner team, the investment that you place in human resources, I can't emphasize enough, is the greatest and most important step that you will take. And doing pre-employment screening, background checking, making sure those individuals are appropriate for your setting. Highly hot topic now, integrity testing, which are question and answer, self-disclosure screening processes that candidates will do online before they even get a face-to-face interview with your human resource professionals. I have clients that work in the prison industry, the long-term care industry, assisted living, and those were industries that were not using pre-employment screening always that effectively, and many of them now are looking at POET to try and get the best candidate on the bus, put them on the right seat, and make sure that they're supported to sustain their workforce through the next 10 to 20, 30 years. So another topic that is happening is the identification. You know, Melissa spoke so well about hazard identification. That's the key term with OSHA. They want an employer to identify situations where they have risk, and these guidances that she mentioned help you see those, but you may have some specific ones, and closure. They absolutely want to see that you as an entity reviewed it, at least considered elimination, considered an engineering control, or considered an administrative control that could make your workplace less hazardous. By incorporating a wellness program into your workforce, we're seeing a growing body of scientific literature that does support that you're going to have a healthier workforce that is, you know, socially, emotionally supported, is going to produce better and avoid these workplace violence events. A great conversation going on in the country, if you're not familiar with it, through the Center for Disease Control, NIOSH, the National Institute of Occupational Safety and Health, has an initiative called Total Worker Health. If your HR professionals that you work with are not integrated into Total Worker Health in the country, I strongly recommend that they go out onto the CDC website and get some information on this. It is the way of HR employee management of the future. So what does OSHA expect? OSHA has really 5 points in a workplace violence prevention program that they want to see. Management commitment. We all can say that, but they really want to see it living proof that when they come to an OSHA initial conference with you, let's say through an inspection or a complaint, they want to know that that CEO really believes in workplace violence prevention specifically, but safety prevention in total, that the employees are involved, that there's some documented means of seeing hazards, hunting and searching for them, if you will, and specifically in this topic that you analyzed it through the reference guidance documents that Melissa mentioned. And how do you prevent those and control those? Some of the control measures she outlined very, very well. And obviously you need a training component. And we certainly see new employee orientation being, oh my goodness, the drinking from the fire hydrant of information. And I want to just encourage employers, think 10 days, 30 days beyond new employee orientation where it was, hey, read all this safety information, sit in front of these DVDs, and therefore go forth and be safe. It's really, really tough on employees these days, and there's too much information, and we need to reintroduce information on the job informally in little bits, and I'll talk about that in a little bit. But record keeping, that OSHA log that she mentioned, it is critical. You might not have incidents on your OSHA log, but I can tell you that one difference between an OSHA log and a workers' compensation loss run is you could have violence-related incidents on your work comp log that don't take on any medical treatment, therefore it doesn't become recordable on the OSHA log, so it's not on the log, but it could be in your work comp data. So be careful with who you share your workers' compensation data with. An OSHA compliance officer will understand that difference and may be able to mine information out of that you don't want to be revealed, but you as a safety organization, a safety committee, for example, want to be evaluating both workers' compensation statistics because they may be more minor incidents, but they relate to workplace violence. So those 5 points then bubble up to these 6 critical. In a program, if you will, you're going to, of course, have a written policy on this. There are templates out there in the World Wide Web. You can reach out to me for examples in different types of settings. They need to be customized, and those templates that you find on the OSHA website, etc., need to be taken into that internal team that I listed earlier and that external team and be vetted for accuracy because certain components may not apply to you. So never rely for an abatement plan. Oh, I got it off the OSHA website. It's the verbiage that you wanted. Absolutely. But if there's no customization documented, OSHA is not going to accept that as a compliance abated policy, for example. Regular training. I mentioned that just earlier in the prior slide. New employees absolutely should receive some basic information about the hazard for a workplace violent event, from the very basic to the very severe. And they should just understand, who do I talk to if I see that? And obviously it's going to be your supervisors, that they would feed that information up the appropriate food chain to the human resource department to deal with that human element of this program. And having an employee assistance program, I have small employers to very large employers across the United States, coast to coast, that have either one or the other, a formal EAP or nothing in place at all. And I just recommend to those that do not have a formal EAP program that they partner with their community social services to connect websites and connect people that they identify that might have some risks or some problems going on in their life that they can informally feed to employees and recommend that they get further assistance. Adopting practices and fair, consistent rules. Man, I was just on a safety audit with a client, and they had some of the self-disclosed to me during the safety audit. We really have unfair and inconsistent applications of rules. And the reason being, they're really having a hard time getting people coming to the employment setting. So what it lends to, though, is disgruntled people that can act out violently. So I really recommend that HR practices of rules are emphasized and reviewed because it leads to the 5th point, the culture. OSHA is very big on behavioral-based safety of late. They know management is the mirror, and we all look in that mirror, and we react to what they're telling us to do. So if there's inconsistent rules and unfair practices from leadership, the cultural dynamic will be heard when an OSHA inspector is doing a walkthrough, and he happens to interview somebody. So that employee can disclose those harmful inconsistent rules, and that can contribute to your OSHA inspection related to workplace violence. So you want to have the communication be that there's zero harm expectations, and if there are noted psychological problems with individuals in your work setting or the patients that you're taking care of, that you are all seeking the appropriate plan to review medications those individuals are on, again, protecting their personal medical information under HR and making sure that your comprehensive workplace violence prevention program seeks the appropriate advice for the clientele you work with and the employees that will be working with them. Some thou shalts or musts for workplace violence that I encourage with my clients across the country is leadership support. And what do I mean by that? It's a CEO who did this in one of my client locations. He got out of his car every day from the parking lot, traversed into the doors that employees would walk through, and as he walked through, he looked for safety issues, not just workplace violence issues, but safety issues of all kinds. Example, he saw the lights in the parking lot were out. He went to maintenance and encouraged people to come out, see the problem, what do you think, and they fixed the lights, a workplace violence contributor if there isn't enough lighting. If he saw things that contribute to slips, trips, and falls, he pulled the employees in that area together and said, let's fix this. And so from leadership's perspective, he was overtly visible in his safety prevention program, and he talked to the frontline employee about it and worked with them to fix it immediately. The other thing he did, he authorized them, empowered them as leaders to have a 1-minute safe and clean meeting at the beginning of each shift. Are we safe and clean to begin our day? And any issue that any employee had, it was like being able to hit an emergency stop button, if you will. And this was a service industry to say, I saw this and it wasn't normal. I think we should fix it. And it allowed dialogue from the very frontline employee to that CEO directly. It was very empowering. And OSHA loves to see that type of stuff happening with leadership. So you need to tailor these programs to your needs, to your particular workforce. Where are you deploying them from the minute they get in their car, come to your properties, or if they're going from their home to other properties? Very important to assess and proactively practice your workplace violence prevention program. Your culture is absolutely going to be assessed by OSHA as well as your frontline employees. So if you're in an organization that allows toxic personality attributes of swearing and erratic behavior and you tolerate that and don't act on it and close that down, that needs to be brought to the attention of an assessment team that's working to remediate your workplace violence prevention program or put a new one in place, because if toxic behaviors are allowed, you will not be successful. A couple others, closing with reevaluate, rethink, and revise. I don't know about you, but the employment setting is becoming very, very diverse, and a policy written, put it in a binder or put it in an electronic file today and dust it off the moment that OSHA shows up or dust it off the moment that the critical crisis event happens will not and cannot be successful. So management has to be actively involved in this, looking for ever-changing warning signs, ever-changing issues in people's lives. Your HR professionals are tasked with great issues, and as in partnership, they will need to practice together to encourage that program to evolve as the organization evolves, because those that are going through mergers and acquisitions, my goodness, I just had a client yesterday take on 50,000 new employees across the country. It's going to incorporate a whole new safety staff, thankfully, but that is the dynamic of the employment setting today, and it really challenges workplace violence prevention programs being put together, but don't be one that doesn't try. Each little step can hugely make a difference in an employee's life by simply making it a better place to work. This is an example of a tabletop workplace violence exercise that we go through where we talk about some of those incidents that Melissa pointed out, and we analyze those from the moment of crisis, stage 1 through 4, to the post-incident response team that needs to come together. We will participate and engage the whole team in that discussion, and I as a facilitator or the security professional as a facilitator manage that time and talk about all the what-ifs and try and dream of what could happen, of course, looking in our crystal ball, but using reference guidances that she's already listed will help you do some of this tabletop stuff. Lastly, once that accident happens, critically important that a team internally plus those external professionals comes together and talks about how that incident played out, what did we learn, and those after-action reviews that we've learned from our military professionals so well in the world of safety are critical also to success, that they communicate to others in professional associations of what that school shooting was like, what was that government tragedy that happened, and how do we react to that. Learning from what others have experienced is definitely a portion of workplace violence prevention. Resources for you. As I mentioned, whether you're in the government setting, the school setting, the healthcare setting, or the retail setting, there are specific guidelines. These are the links to those reference documents that have wonderful sample policies. They have wonderful training guidance, and they can connect you with other professionals that are in your industry that are working on the same topic.
Thank you, Lori. Let's close with just some general tips on how to prepare and handle an OSHA inspection. So these tips really are not just for an inspection that could occur resulting from a workplace violence incident. They're really tips that you could use for any OSHA inspection. So the slide I've got up now really kind of summarizes the goals. I mean, obviously you want to come out of this inspection with the least liability you possibly can, and you want to do that while preserving your relationship with the local OSHA office. And then, of course, on the back end, the whole time you want to be thinking about, assuming that we're going to get cited, what kind of settlement do we want? And then you've also got to think about any civil liability issues that may be lurking out there if you've had an injury or you've had a fatality. So the first thing that you should be thinking about, and you should know this really now, is who's going to be the main contact with OSHA. And the reason that's so critical is you really want to control the flow of information this whole time. You think about all the information out there about your facility, about your company that deals with safety, and you think about funneling that down to a single contact. I mean, that's what you want to do, because at the end of the day, you want to know every piece of information OSHA knows, and probably more. So unless you've got that single person that's going to deal with OSHA's request for information, you're not going to be able to track it all. I've certainly come into inspections late in the game where I say, well, what documents does OSHA have? And nobody knows, because they've just kind of turned OSHA's team loose in all their procedures and policies, and they don't really know what OSHA has and doesn't have. So it's critical that you control the flow of information, and that theme sort of runs throughout all of these tips. So standard operating procedure, I mean, obviously that compliance officer's got to be accompanied at all times by somebody. You're not just going to turn them loose in your facility to roam free. They're going to have to submit document requests to you in writing. And again, that's all about controlling that flow of information and understanding what information they have at the end of the day. Photographs and video, I mean, obviously OSHA's got the right to take photographs and take videos. You're going to want to take side-by-side photographs and side-by-side video, because you can't rely on the fact that you're going to promptly get those photos and videos from OSHA. So those are important pieces of information. In terms of protecting your trade secret and business confidential information, you really can, the reason you often do that is that you may have a civil lawsuit lurking out there. So you certainly want to protect the information that's going to be in OSHA's file. So let's take a simple example. You may have a procedure that your employees use for locking out equipment before they do maintenance on it. Well, that's a procedure you developed. You wouldn't turn it over to a competitor. So that's really business confidential information. So you want to make sure you mark all that information that way so that it can't be released through a FOIA request. The first thing that's going to happen is OSHA is going to show up, the compliance officer. COSHO stands for Compliance, Safety, and Health Officer. The OSHA inspector is going to show up and is going to meet with the employer representative, any contractors that are involved, in the labor union. And the first thing OSHA is going to say is, we're here to investigate whatever it is. So that's going to set kind of the scope of that inspection. And that's the time when you can say to OSHA, we'd like you to submit document requests in writing, all that type of thing. OSHA is not permitted to come in and do an inspection unless the employer consents or OSHA goes out and gets a warrant. In 16 years of doing this, I can think of one time when I told the employer to request a warrant, and that's because we had a jurisdictional issue involving the Coast Guard. It rarely makes sense to say to OSHA, we're not letting you in, go get a warrant, because it's difficult to think of a time where they really don't have the right to come in and inspect. So to me, you're much better off understanding the scope of the inspection and saying, yes, we consent to have you come in and investigate this particular incident. The next thing OSHA is going to want to do is take a tour of the facility, and that is going to include an employer representative. Again, if there's a contractor somehow deeply involved in this, they may have a representative. If that facility is represented by a union, if the employees are, they'll have a union representative there as well. So you should really be thinking now, or even know now, who's going to be our walk-around representative? And that's, of course, going to be the time when you're going to be taking your parallel videos and parallel photographs. It's also important, I think, to explain to OSHA on the front end, particularly if you are in a retail facility, a manufacturing facility, someplace like that, that you really can't have OSHA interviewing employees for a long time on the production floor. If you're in a manufacturing facility, then obviously, pulling employees away from their job for an extended conversation with OSHA is not safe. It just doesn't make sense. In a retail facility, you can't really be pulling those people away from customers. So to me, the way to handle that is to say, we're happy to have you talk for a few minutes with employees as we walk around, but it's only going to be for a few minutes. If you want to interview specific employees, we're happy to set aside a conference room for you and bring the employees to you to do the interviews. And again, that's all about control. You're much better off knowing who they've interviewed rather than having them kind of roaming the floor. Finally, don't stage anything. I've had a couple of clients over the years that have OSHA's asked them to kind of stage an operation. They've done it, and to say Murphy's Law applies, it does. I mean, it seems like invariably something goes wrong when those things are staged, and you really don't have any obligation to do that. Plain sight doctrine, you law and order fans, I mean, as OSHA's doing that walk around, anything they see, let's suppose they come in to investigate a workplace violence incident, and they come into a manufacturing facility and see that all of the emergency lighting is out. Well, I mean, that's fair game. You're going to get that citation. So this sounds paranoid and crazy, but you might, if you've got a big production facility in particular, you might think about the route. I mean, OSHA's going to want to go see where did this incident happen. Think about the best way to take them there. My very first boss a million years ago, we used to do a lot of work at refineries, and he would actually put the compliance officers in a van and put newspaper over the windows, and we would drive them to where they wanted to go and drive them back, which I thought was crazy and still do. I'm not suggesting you do that, but you may want to give some thought, especially in industrial facilities, as to how you want to handle that. So we've talked about all document requests to a single source. It's just like a document request you get in civil litigation. I mean, you've got to think about, are things privileged? You've also got to think about, is it a reasonable request? I mean, OSHA is required by statute to perform a, quote, reasonable inspection. Coming in and asking you for all of your safety committee meeting minutes from the dawn of time, that's probably not reasonable. So certainly give thought to that as you look at the requests. OSHA, of course, always wants the document right that second. Don't be intimidated into doing that. I mean, there's no reason they can't give you a list. You can't pull the documents together in an orderly way and then send them to the compliance officer in his or her office. There are certain documents you've got to produce quickly. Injury and illness logs and records 300, logs 301s, those have to be produced within 4 hours. A couple of program documents, hazard communication, lockout, tagout, there's no time limit on that, but those particular standards say you have to produce those records on request. So those are not requests that should take you a terribly long time, in contrast to, say, safety committee meeting minutes or something a little bit more substantial. Important to remember that statements by managers and supervisors, and what I mean by manager and supervisor is anybody from kind of crew foreman on up. That's all binding on the company. That's an admission on the company's behalf. So if your frontline supervisor says during that walk around, we knew that security camera was broken, but the replacement part was very expensive, that's just as if the CEO said it. So that's a very damaging statement. So I think when it comes to management interviews, you need to treat those somewhat like a deposition. I mean, first of all, your walk-around representative needs to understand that whatever he or she says is binding on the company. And when it comes time for OSHA to sit down and interview managers and supervisors, they are permitted to have representatives present during that interview. That could be a company lawyer, that could be an outside lawyer, that could be another manager or supervisor, and I would urge you to exercise that right. And as I said, you really should, to some degree, treat it like a deposition. I mean, there should be some preparation before the interview. You should talk about what questions are going to be asked, how things are going to be handled. I like those interviews to come across like depositions. I like a lot of yes answers and no answers, and I don't have that information answers. So as I was saying, I think, you know, the key point with these management interviews is you really should prepare for them and treat them somewhat like a deposition. So to kind of put this in context before I get to employee interviews, you know, the management interviews in this current environment are likely to be fairly confrontational. So I think, you know, you can't spend too much time prepping for them. In terms of employee interviews, hourly employee interviews, OSHA's got the right to question employees privately. I think particularly in a workplace violence situation, employees oftentimes are not comfortable with that, and they want another employee with them, or they want a member of management with them. That, for whatever reason, can be a tricky issue. Some area offices, they'll let anyone be, as long as the hourly employee says, I want this person there, they'll let it happen. Other area offices say, no, it has to be a private interview. The union steward being in there doesn't mean the interview is not private. What I've found is that, you know, it's best just to sort of let it happen. If that employee, if OSHA says no, it's better to try to convince the employee to do the interview. But that often is kind of a tricky issue. Even if the employer is not going to be present for that employee interview, you can still, again, kind of control that process. I mean, I think particularly with a workplace violence scenario, you know, you're going to want to have someone from HR sit down with an employee and explain why OSHA's there, the kinds of questions that are going to be asked. If you've done workplace violence training or have a program, you might, you know, pull that out and kind of refresh their memory on that. And I think that it's important to circle back to that employee after the interview and try to understand what was said. Now, that employee doesn't have to tell you. They can say, what I say to OSHA is private. But, I mean, I think if there's no harm in asking that question. And, again, that's all a piece of controlling the flow of information, because I think you want to understand the sorts of questions and the sorts of information OSHA's getting during those interviews. So just to put this all in kind of context, you know, you're going to have the opening conference, you're going to have the walk around, OSHA's then going to make a bunch of document requests. Then OSHA's probably going to go back to their office and look at the documents. Then they're going to come back, they're going to want to interview specific employees, and they're probably going to interview managers last. And what I have found over, say, the past 5 years or so is that some of those interviews can be fairly, I mean, contentious may be the wrong word, but I think the questions are often phrased as, you know, isn't it true that this happened, and isn't it the case that this? So the questions are not open-ended, and oftentimes OSHA's clearly trying to get those managers to say something specific to support their case. And just to clarify, the private interviews are only for hourly employees. If it's a management employee that's being interviewed, then the employer absolutely has the right to have a representative present during that interview. So when we talk about workplace violence inspections, as I mentioned at the beginning, I mean, they're different. I mean, everyone's upset anytime someone is hurt or, heaven forbid, killed in the workplace. I think when it's a workplace violence scenario, they're even more upset because it's just a terrifying situation. So I think it's important that you really advocate for your employees during this OSHA inspection. Obviously, use your employee assistance program. OSHA interviews are voluntary. I mean, OSHA can issue a subpoena to interview a particular employee if they want to, but until that subpoena gets issued, that employee does not have to be interviewed. So if you've got an employee that's that upset and really does not want to do it, then you can certainly tell that to OSHA. So, I mean, I wouldn't feel as if you need to produce every single employee that OSHA wants. It's fine to push back a little bit and say, people are upset. This particular person does not want to talk with you today about this. Maybe they'll want to later, but, we're not going to make them do it. So I think it's important to keep that in mind. In terms of recording interviews, by tape or by video or by tape recorder, OSHA technically doesn't have or not have that right. A lot of OSHA compliance officers have these little digital recorders now. What I tend to allow them to do is to record it if they want to, as long as they're going to send me a transcript of it. So those are sort of some tips for handling an OSHA inspection. By the time you get to the closing conference, and that's when OSHA is going to tell you what citations they're going to recommend, ideally you know as much as they know, if not more. You should know by that point exactly what you're going to get cited for. So I think that the closing conference can be a time when you can present additional evidence to cause OSHA not to issue that citation, but it's often just a listening experience where you want to know as much as you can about what the citation is going to be and why OSHA is going to issue it, so you can start to think about your legal strategy for responding to that citation. For workplace violence inspections, there are some pretty typical documents OSHA is going to ask for. Any assessments of workplace violence hazards, medical records, a lot of the documents we talked about on the front end that could form the basis for showing that the employer recognizes that workplace violence is a hazard. In terms of the walk-around, it's probably going to be limited to the areas with the greatest potential for violence. And then I mentioned that for healthcare facilities, I've had numbers of clients call me to ask, OSHA wants to take pictures of patients. Can they do that? The answer is absolutely not unless a patient's going to consent to that. So that's pretty unique to healthcare, but that issue does come up. In terms of interviews, they're going to be interviewing the people you would expect. The people that either have contact with the patient, have contact with the customer, or the management employees who are going to get reports of that type of situation happening. And then as I mentioned during the closing conference, OSHA is going to tell you what they're going to recommend in terms of citations, and you may also talk with them about what abatement measures they're going to recommend. And that would probably be the right time to ask them, if you're going to recommend additional abatement methods, why is it you think our existing abatement methods are not sufficient? So those are some tips for handling an OSHA inspection. Let me turn it back to Kathleen to maybe field some of the questions that have come in as we've been presenting.
I'm happy to. We have about 5 minutes remaining in our program today, so we'll have time for a few. I have one here that says, if a company contracts another company to provide a service that puts contract company employees at risk, who is responsible if that contract employee experiences workplace violence?
That's a much longer answer than 5 minutes, unfortunately, but let me make it short. Well, let me give you the classic lawyer answer, which is it depends. If you have a situation where you have, for example, temporary employees who are doing the same work your employees are doing, then you're likely going to be responsible for that because you are supervising and controlling that employee. If you have a scenario where you contract out, for example, for your security services, you control their environment in terms of if they need a panic button, you're the one to install it. But the whole reason you hired that outside service is they are the experts in dealing with security. So you're going to have less of a responsibility in that situation. So there's no bright line answer.
Okay. I have represented companies who rely on lack of duty to prevent criminal violent acts by disgruntled employees. They've refused once to settle in a serious injury. Any advice on how to convince a stubborn client?
Well, that may work that's not really my area. That may work in a civil liability context. That's not going to work with OSHA. So, the way to convince them may be, you may not want to settle this civil suit, but you're going to need to do something to address this hazard or you're going to have some significant OSHA problems. And of course, once you get that OSHA citation, especially if you're dealing with an outside contractor where you don't have the workers' comp protection, then that's going to increase your liability. All
right, we have one here that says, is OSHA targeting workplace violence in schools for future investigation? And do you know of any plans for OSHA to create guidelines for schools like it has for late night and healthcare and social service workers?
I don't, and certainly public schools in many states, OSHA doesn't have jurisdiction over state and local governmental employees. But Lori, you may know more about that than I do.
I would concur with you. I have not seen active groupings to say that we need an OSHA guidance. Those are usually very delayed because they take so much time. But know that the insurance entities that work with cities and states, and I did work with municipal safety organizations, they are providing information because of the trending themselves. And so some of the insurance industry have developed best practice guidelines related to schools as they service them for loss prevention and risk management.
Great. I have one here that asks, how do you think the workplace violence prevention process affects the subsequent employee disciplinary process?
Lori?
It's really an HR question. I'm not an HR professional, but we do see that workplace violence and prevention programs will help mitigate the quantity and frequency of challenges that HR professionals have related to violence in the workplace, whether it's just, horrible language or behaviors. So prevention practices can help reduce those incidents, and they need to be complementary, again, back to my point of the comprehensive team that comes together to work on this, because you have to respect many other laws, ADA, HIPAA, and be practicing fair rules and regulations against, if you will, against employees in the workplace as to how they perform. So not an easy topic, very gray areas, lots of legal issues and safety issues. Takes a big, huge team to work it all out.
And I have two final questions that are points of clarification. The first one asks, what is PPE? And the second asks for clarification on whether private interviews are required only for hourly employees.
I can answer both. PPE stands for personal protective equipment. That's going to be respirators, gloves, hard hats, safety shoes, any of that kind of thing. Private interviews are only required for hourly employees. Any management employees from frontline supervisor on up, that employer's got the right to have a representative in that interview.
Wonderful. And that brings us to the end of our time together. So on behalf of LexisNexis, I would like to thank Melissa and Lori for an excellent program today. For our attendees, please take a moment to complete the survey that will appear for you at the close of the webinar. It provides us with your feedback that allows us to continue to tailor programs that you want the most. Thank you all, and have a great day.